Hello, I'm Gretchen Helfrich, an attorney here at Loevy Loevy. And with me today is my colleague Rachel Steinback. Hi, Rachel.
Hi, Gretchen.
Rachel, in your practice, you've worked a lot on criminal justice issues related to juvenile defendants. That's been a real focus of your work. And what I want to ask you about today is a case that's before the Supreme Court this term, a case that reform advocates like you are keeping an eye on. And the case is Montgomery versus Louisiana. So maybe you can start just by summarizing what the case is about.
Sure. Montgomery versus Louisiana is a case involving a juvenile, a 17-year-old, who was convicted and sentenced mandatorily to juvenile life without parole. In 2012, the U.S. Supreme Court held in a case called Miller versus Alabama that mandatory juvenile life without parole sentences were unconstitutional. A number of states have determined for themselves whether Miller should apply retroactively to individuals sentenced mandatorily to juvenile life without parole in their state. Louisiana is one of the few states which has held that Miller should not be retroactive, meaning everyone who was sentenced prior to 2012 to mandatory life without parole as a juvenile is going to keep that mandatory sentence. So what Mr. Montgomery has done is approached to the Supreme Court to ask the Supreme Court to declare Miller retroactive across the board to all the states so that he can seek relief under Miller.
Now, Montgomery is legally a really complicated case, actually, even though the core issue that's interesting is the one that you've just described. There's a lot of other stuff going on in that case that may make the outcome really hard to understand
Yes.
when it actually happens. But let me ask you this. In brief, how does the Supreme Court decide whether a rule like Miller or a case like Miller has retroactive application?
Sure. When the U.S. Supreme Court announces a new ruling, it can be either a procedural rule or a substantive rule in criminal law. And without getting into all of the legal vagaries, essentially what Mr. Montgomery is asking the U.S. Supreme Court to say is that when it declared juvenile life without parole, when imposed mandatorily, unconstitutional, it was declaring a new substantive rule that would have to apply retroactively to all the states.
So roughly, if a holding by the Supreme Court is substantive, a constitutional holding is substantive in the criminal law area, it's retroactive, roughly. And
exactly.
If it's procedural, it's not.
Yes, exactly right.
With a bazillion complications that
Yes.
we'll not get into here.
Yes.
Okay, so Montgomery is asking the Supreme Court to decide that this is a substantive holding. And if the Supreme Court says yes and says Miller's retroactive, that will mean what for people who committed offenses when they were juveniles and were given life without parole sentences on a mandatory basis?
That will mean across the country, every individual who is a juvenile was mandatorily sentenced to life without parole will get a resentencing hearing so that the trial court can take into account what the U.S. Supreme Court has called the hallmark features of youth, giving great weight to those hallmark features, which are mitigating, and determine what an appropriate sentence should be for that individual.
Now, when you say the hallmark features of youth, is that an instruction to the trial courts to consider, let's say, 14-year-olds generally, or the 14-year-old that's in front of them?
Both. It is an instruction to each of the trial courts, first and foremost, to recognize that youth are different than adults. Young people are more impulsive, they're more impetuous, they're worse at making decisions and understanding consequences as adults. And their brains are simply not developed into the adult brains that you and I have. So the U.S. Supreme Court, in its holding in Miller, told trial courts, you need to take into account the fact that children are different. And not only are children different as a general rule, but then the trial court, of course, has to take into account the specific individual before him or her and decide what specific characteristics of that youth might mitigate against a sentence of life without parole.
So life without parole is still a possible sentence for a juvenile offender. It just can't be imposed on a mandatory basis. There has to be individual consideration.
Exactly right, though the U.S. Supreme Court in Miller was very explicit in saying that it would be the rare juvenile offender whose crime reflects irreparable corruption who should be resentenced to life without parole. So although it is an option and still on the table, as you said, it should be reserved for the very rare defendant who has demonstrated that he or she has no ability to reform and be released back into society.
And so far, many states have already decided for themselves that Miller will apply retroactively. And Illinois is one of those states, right?
That's exactly right.
And you had a client who got a resentencing hearing because of the Illinois Supreme Court's ruling. Well, actually was the subject of the Illinois Supreme Court's ruling. Talk a little bit about that case.
Sure. So my client his name is Adolfo Davis, and after the U.S. Supreme Court's ruling in Miller versus Alabama, his was the first case to go before the Illinois Supreme Court. He, at the age of 14, was arrested, prosecuted, and convicted and sentenced mandatorily as an adult to life without parole. So he has been fighting that mandatory sentence for more than 20 years. And after Miller, his case wound up before the Illinois Supreme Court. And in his case, the Illinois Supreme Court said, yes, Miller applies retroactively, and that not only Adolfo, but every individual serving juvenile life without parole on a mandatory basis in Illinois should get a resentencing hearing.
How many people is that?
It's roughly 100 to 120 people. So there are around 100 individuals in Cook County who are serving mandatory juvenile life without parole, and approximately 20 throughout the rest of the state.
And are these, I assume, but maybe I'm wrong, mostly men?
Overwhelmingly men. Yes.
Okay. So tell me what the hearing was like. You had a hearing earlier this year in front of a trial judge to have Adolfo resentenced. Tell me how that went.
Well, it was very interesting. It was the first hearing of its kind in Cook County, and it ended up being 11 hours. We had a number of witnesses come and testify in mitigation in support of Adolfo. So he has now spent 25 years in prison. As I said, he was 14 years old when he was arrested. He was the youngest person to enter the Department of Corrections. He has been in maximum security facilities since the age of 17 because of his sentence. And so when we went before the judge, the emphasis was, as Miller instructed, to talk about the hallmark features of youth, to talk about Adolfo's lesser role in the crime. He was a lookout. He was in a situation where two older men had asked him to look as a lookout while they entered and did what he thought was going to be a robbery. They ended up shooting people, two of them fatally. So because Adolfo was with them, he was arrested, charged, and taken to trial along with them for murder, even though he didn't pull the trigger or commit any of the murders.
Or know that it was going to happen.
In fact, one of the victims, very sadly, was one of his friends, which is why when he went along that night, he had no idea that there would be any violence because they actually knew some of the people in the apartment that they went to.
Well, so tell me, it's a little confusing to me because, so you have Adolfo Davis now standing before a judge, a 39-year-old man or 40-year-old man, and you can say generally, here's what 14-year-olds are like, but you can't say, here's what the 14-year-old Adolfo Davis was like.
You know, in Adolfo's hearing, as I'm sure will be the case in many other hearings, he had already been in the system in one way or another. For example, he lived in an impoverished house in an impoverished community. So there were DCFS reports describing what Adolfo was like, what his family situation was like. There were school records. So there actually was a wealth of evidence about what Adolfo was like as a 14-year-old.
Adolfo had a paper trail.
He had a paper trail, exactly. And this is before Facebook and Twitter, so not of the social media variety, but there was actually a wealth of evidence. One of the witnesses that we presented at Adolfo's rehearing was actually Father David Kelly, who runs Precious Blood Ministries here in Chicago. And he is someone who met Adolfo right after Adolfo was arrested and taken to the juvenile detention center. And he has known Adolfo over the past 25 years. And so he actually knew Adolfo as a 14-year-old. And over the past 6 to 8 years has worked with Adolfo and had Adolfo mentor some of the at-risk youth that attend Precious Blood Ministries. So we had witnesses from all aspects of Adolfo's life who could testify to who Adolfo was both at 14 and at 38 at the time of his resentencing.
Now, Adolfo had, we should let people know, Adolfo was not resentenced. The judge left his sentence intact. That ruling is being appealed.
Well, and one of the problems is she said that she would not disturb the ruling. Actually, it was her new ruling to make. So essentially what Miller did was say, the old sentence doesn't apply. You're starting with a fresh slate. what Judge Patron did at the resentencing was said, well, I see no reason to disturb this prior ruling, which is an incorrect question. What Judge Patron did was, though, in substance, resentence Adolfo to life without parole.
For non-lawyers listening, there's a big difference between a judge reviewing something from scratch or I should say a judge deciding something from scratch and a judge reviewing someone else's decision.
Exactly.
And it makes a big difference. And if you don't like the prior decision, you definitely want the judge deciding from scratch, which is essentially what you're arguing on appeal, is that she was supposed to decide from scratch.
Exactly. Both that she was supposed to decide from scratch and that despite the wealth of evidence and testimony she heard supporting Adolfo and demonstrating who he is today and how he, but for every reason, for his lesser role in the offense, his very young age. I mean, he was one of 3 children in the entire state of Illinois to be sentenced mandatorily to juvenile life without parole. So we are both saying that she applied the incorrect standard and that she discredited every last shred of evidence that supported his release and only credited the testimony that was provided by the state.
Now, maybe this is too detailed a question, but in the resentencing hearing, were you asking the judge to parole him or just to say he was eligible for parole and then he would have to go through some parole process, or to say he should just be released right now?
Well, in the state of Illinois, there is no more parole process. Actually, you are sentenced to a finite number of years. So what we were asking was for the judge to sentence Adolfo to time served. We were saying that 24 and a half years for a child of 14, given his role in the offense and all of the hallmarks of youth and other mitigating factors, was an appropriate and perhaps even too lengthy sentence. I mean, it's clear to everyone that knows Adolfo that nothing is served by continuing to house him in the Department of Corrections.
So, Rachel, in terms of other inmates who, in Illinois or maybe elsewhere, who are going to have these resentencing hearings, here's a scenario I imagine, and tell me if this is something that's actually of concern. Adolfo Davis, your client, was in some ways a model inmate. He participated in a lot of programs. He really pulled himself together and really has transformed himself into, exactly the kind of productive member of society that people want the Department of Corrections to produce. But I can imagine someone else going in at the age of 17, they've been sentenced to life without parole, and they think, well, I'm stuck in here. What's the point of being good? What's the point of trying to show that I am reformable or reformed? I'm not getting out. There's no benefit. There's no incentive to me to do that. And so now they go before a judge to be resentenced, and it turns out they've spent the last 25 years or whatever being a jerk because there was no reason to do otherwise. Are they going to find themselves at a disadvantage?
Well, in sending these cases back to the trial court, the court is supposed to put great weight on the hallmarks of youth. So although it is wonderful that we have, a decade to decades of information about each of these defendants, really what the court is supposed to be focusing on is the hallmarks of youth, who this was when he or she was a child and committed this offense, what the circumstances of the offense were, what their family life was like, what support they had. And then as a bonus for some of these young men and women, we'll have the benefit of hindsight of having 20, 30 years of data. Now, not only, you talk about the inmates themselves being disincentivized after receiving a sentence of life without parole, but even if they are incentivized, even if they want to do well in the Department of Corrections, for the Department of Corrections, there is no reason to provide services to these people. If they figure they're never going to get out, then why invest a penny in educating them or providing them with vocational programs? So it's not even so much a function of these defendants giving up and saying, you know what, forget it, I'm not going to try. It's really the way the system has treated them.
So they have less access to classes, vocational training. Is that what you're saying? Those sort of rehabilitative programs that other inmates have some access to?
Absolutely, because, at least in theory, our Department of Corrections is rehabilitative. And so it does have some programs, albeit fewer and fewer. But it's not offering those programs to people who, in the department's view, don't need rehabilitation because they're never going to see the light of day and go back into the community.
Rachel, do you have a guess, a prediction about how Montgomery is going to come out?
You know, it's really impossible to tell. I know everybody wants to read the tea leaves, but it'll be interesting to see. This is the first time that the U.S. Supreme Court is going to be taking up an issue of retroactivity of Miller. So at this point, it's really anyone's guess. We're all waiting to see.
All right, thanks very much, Rachel.
Thank you, Gretchen.